Assalamualaikum warahmatullahi wabarakatuh, and hi everybody. Today I would like to present about our study. The title Occupier Legal's Duty to Prevent Injuries, Reviving Tourism Through Understanding Standard of Care. Me myself, Muhammad Shahizam bin Musa from UiTM Pahang, and I would like to introduce our team member. First, Surya Fadilah Mat Fauzi, our team leader. Samsina Rahman, Muhammad Azim bin Zainal, and also Dr. Ida Rosnita Ismail. Okay, let's go to the next slide. For introduction, as we know, COVID-19 had affected the tourism sector. It's happened especially in Malaysia and caused our Visit Malaysia 2020 campaign had been cancelled. Okay, according to Malaysian Associations of Hotel (MAH), has estimated a loss over than 500 million revenue because of booking cancellation. More than 2,000 staff were being laid off. More than more than 9,000 tourism staff were asked to take unpaid leave, and also more than 500 tourism staff got pay cut. Okay, on 11th October 2021, Malaysia implemented recovery plan phase 4 hotel accommodation premise. This implementation had been made after almost 90% of the adult population fully vaccinated in Malaysia, and it caused the tourism premise to be reopened for once again. This is statement by the Star in 10 October 2021. Okay, for post-movement control order (MCO), restructuring the tourism sector by restoring visitor trust on safety. Okay, the COVID-19 pandemic undoubtedly had added a special concern with respect to duty of care and standard of care to be adhered by tourism player during reopening tourism while ensuring the safety of visitors. For problem statement, after recovery plan phase 4 hotel accommodation premise implemented, Langkawi actually becoming the first travel bubble pilot project and targeting 400,000 visitors in the end of 2021. The government carefully taken a prevention action and practically using SOP suggested by MKN. But during the reopening process, there are some incidents that will happen. Okay, first in Langkawi for October 2021, 59 people found positive comprised local staff and close contact involving family members. The outbreak had stemmed from one of hotel employees' home due to failure to comply with standard operation procedure (SOP), and the virus spread to the other hotel staff based on New Straits Times report in 2021. Okay, second incident, 6 years, 6 years old children actually fall to her death during family outing in Penang on 18 October 2021. The parents said their children suddenly dashed to elevator and closed the door without any companion. After 10 minutes, the parent been informed by hotel staff about the children dead body at hotel second floor. This is report had been made by the Star in 2021. Okay. Um, number three incident, a mother, Leong Choi Kit, 34 years old, and her children, Ng Hon Jun, 4 years old, found drowned in resort pool at Dungun on 23rd October 2020. Dungun District Police Chief Superintendent Baharudin Abdullah said both mother and children can swim and distant from incident place and their room only 50 meters. Okay, reported by Sina Harian 2020. Based on Langkawi issue and two tragedy discussed above, The needs of clarifying suitable standard of care to be practiced are desperately needed. The main objective of this paper is to examine the standard of care required under tort law with respect to tourism player as occupier under tort law. So this is our main objective for this paper. For methodology, this paper used doctrinal methodology. Doctrinal methodology is adopted in this paper actually, as it traces legal precedents and critically analyzes relevant case law, statute, and other legal sources. The study reviewed the case taken from English common law and Malaysian law. For this study, case were chosen based on the keyword standard of care, which led to the discussion on the standard of care on the occupier. Okay, refer to the table below. Okay, in this study, we used the Stamp Park Place in Renbahat versus Liu Li in 2017. Okay, and the sources are from LNS, Legal Network Series, from Current Law Journal. Okay, this is the sources and the case that we review for uh, structuring the standard of care in this paper. For the discussion, actually this paper, this study had found that based on standard of care of tourism player as an occupier, there is three types of entrant. Start with contractual entrant as dominant entrance. Number 2 followed by invitee, number 3 licensee, and number 4 trespassers. Okay, actually from the list of type of entrant, trespasser has been excluded from the discussion because trespasser is illegal entrance. So we discussed only the legal entrance. That's mean the contractual entrance had become the most dominant entrant in this list. So the resources we taken from Witt versus Laken and Co. McLennan versus Sega, Stamp Park Place and Renbahat, and also Sutton versus Bottle Corporations. Okay. In this discussion, we also have a case review. Okay. Refer to Stamp Park Place and Renbahat versus Liu Li, 2017. Okay. The visitor had been categorized as invitee, found drowned in a pool 1.5 meter depth. The respondent in this case claimed that the appellants failed to take adequate precaution and provide adequate warning to guarantee that the swimming pool was safe to use. Then, in this discussion, we also found that in terms of standard of care toward an invitee, to determine whether or not the occupier can be held negligent, the court must ascertain whether the inviter knew or ought to have known that the invitee was exposed to unusual danger. So unusual and danger becoming the keyword for this study actually. Okay, based on Glasgow Corporation versus Moore in 1943. Okay, then the ruling of court refer to the same case. Respondent in this case failed to describe the depth of the pool as unusual danger, or that the disease ought to be protected from this danger. The respondent has failed to prove negligence against the appellants based on the pleading and circumstances put forth in the record of appeal. So the occupier, the owner of the premise, had been warned for this case. Okay, this is the framework that we had construct from the cases discussed before. So the title of this framework, General Standard of Care Frameworks. So in this framework, it starts with occupier, theme park owner. Okay, someone has who has sufficient degree of control over premise, need not have actual possession of it. Okay, O duty of care. Okay, lawful entrance means the legal entrance. We have three types: contractual entrance, invitee, and licensee. Okay, contractual entrance, main purpose entrance, ensure the premise is safe for occupation of main purpose entrance. Okay, ancillary purpose entrance, ensure the premise is reasonably safe for that particular purpose. Okay, for invitee, legally authorized entrant, business visitor. Okay, must warn the entrant. This is actually standard of care for occupier, which is must warn the entrant as to any probable and unusual dangers that the occupier knew or ought to have known that might cause injury or harm. Therefore, reasonable precaution must be taken to safeguard the safety of entrance. Okay, if happen a breach of duty of care, so it will open for litigation. Okay, for licensee, under obligation not to expose the licensee with the dangerous condition, warn the licensee on the dangerous that is known to the occupier. Okay, so if they are not comply, the occupier not comply for this term, so it's also open to litigations. Okay, if any um, breach of statutory duty, non-compliance of SOP happen among the occupier, so it will open for litigations. Okay. That's all my presentation for our study. I would like to say thank you and please stay safe, everybody. Thank you again.